All right, I think we have all 5 of our judges here, so if I could just have our judges turn on their cameras, so I can introduce you. Bill, Zach, Claudia trying to turn her camera on. There we go. All right, so we have a 5-judge panel for our 2024 Trial by Combat Play-In Championship, and I'm going to just introduce them very, very briefly, one at a time. Claudia Cornelison is an award-winning AMTA alum from Georgia State. Dylan McCauley is also an AMTA alum from Richmond and competed in our inaugural Trial by Combat in 2018. Zach Cloud is an attorney in Boston and the coach of BU's undergraduate mock trial team. Bill McGinnis is a lawyer and probably has been judging mock trial longer than I've been alive. And last but not least, our presiding judge, Disha Walia, is a 3L at Drexel Klein Law and is the only competitor in Drexel Klein history to win the AAJ Regional Championship twice, which is one of the 2 big regional competitions that every law school competes in every spring. So with that, I'm going to turn it over to Disha. Good luck to both teams.
Thank you, Phil. Counsel, are you guys?
And sorry, Disha, I'll just ask our judges other than Disha to turn the cameras off.
Great. Are you guys ready to proceed?
Yes, Your Honor, the defense is here and ready to proceed.
We're ready to proceed as well.
Okay. I understand that there's no housekeeping, so opening statements?
Yes, Your Honor, before we proceed with opening statements, we'd just like to move Exhibit 4 into evidence. It's a photograph of the little girl that this case is about.
Do you have any objections, defense?
No objection.
Okay, then it's in.
With that, we're ready to proceed. If I could just have 1 second to fix my camera angle.
Sure.
May I proceed?
You may.
The defendant pulled too hard, and Charlotte Lee paid the price. It's midnight on January 2nd of 2019, and Barbara Lee's water breaks. She calls her doctor, rushes to the hospital, and prepares for the hardest day of her life, giving birth. But when she gets to that delivery room, when the doctor tells her to push, well, something goes wrong. The baby gets stuck. The baby can't breathe. So Barbara looks to her doctor for help. But that doctor is panicking. See, she knows that that baby has just minutes to live. She can practically hear the sound of the ticking clock. So instead of following standard procedure, instead of gently guiding that baby, the defendant grabs its head and yanks. Members of the jury, this is that baby. Her name is Charlotte Lee. She's 5 years old now, and she's paralyzed for life. Her right arm won't move. Her right hand won't move. All because of the actions of that doctor, the defendant. You're going to hear that the defendant pulled too hard. And Charlotte Lee paid the price. That's why Barbara and Avery Lee are bringing a claim of negligence against the defendant. Now, in bringing that claim, we take on a burden of proof. We have to show beyond a reasonable doubt, or by a preponderance of the evidence, meaning more likely than not, that the defendant acted unreasonably when caring for Barbara and Charlotte Lee, and that in doing so, she harmed Charlotte. We're going to meet that burden, and we'll do it by focusing on 3 facts. First, the defendant ignored the risks. Second, the defendant pulled too hard. And third, Charlotte Lee paid the price. So let's start with that first fact. The defendant ignored the risks. You see, when the defendant takes the stand today, she's going to have to admit to you that she knew that there was a risk of birth complications months before she ever stepped into that delivery room. The same complications that paralyzed Charlotte. But you're going to hear that the defendant didn't do anything about it. You'll hear that the defendant didn't so much as warn Barbara and Avery Lee that birth could go wrong. She didn't so much as warn Barbara and Avery that their child could be paralyzed. That brings us to that second fact. The defendant pulled too hard. For that, you're going to hear from a medical expert, Dr. Nat Garson. And Dr. Garson's going to tell you that there's one thing that a doctor should never, ever do when a baby gets stuck during delivery. And that's pull hard. You're going to hear from multiple different accounts in that delivery room that that's exactly what the defendant did. Third, when the defendant pulled too hard, Charlotte Lee paid the price. Members of the jury, you're going to hear exactly how the defendant's actions harmed Charlotte. You're going to hear from Dr. Garson, and all of the scientific and medical literature points in one direction, points to the defendant. You're going to hear that the only reasonable explanation, the only one for Charlotte's injuries, is the defendant's actions. Now, as you listen to this trial, I want you to remember that this case comes down to the defendant's decisions. The decision to ignore those risk factors, to proceed with a traditional birth. The decision to hide those risk factors from Mr. and Miss Lee, to not even give them the choice to do something different. The decision to abandon standard procedure, grab Charlotte's head, and yank. The defendant pulled too hard. And Charlotte Lee paid the price. That's why at the end of this trial, I'm going to come before you again and ask that you find the defendant liable. Thank you.
Thank you, plaintiff. Defense?
Yes, Your Honor. May I proceed?
May.
It wasn't fair, but it wasn't her fault. A moment ago, Miss Volpert just told you a lot about a sweet little girl who was paralyzed at birth. And look, members of the jury, everybody in this courtroom can agree what happened to that baby girl. It's a tragedy. No child should be hurt at birth. But today you're going to learn that what happened to that baby, it was not Dr. Wax's fault. Because when Dr. Wax walked into that operating room to deliver that baby, you're going to learn that she didn't ignore the risks. No. She walked into that room with decades of experience. Thousands of successful child deliveries. And today you're going to learn that when Dr. Wax was met with the obstacles during that birth, she delivered that baby. She delivered that baby safely, reasonably, and to the best of her ability. It just wasn't fair. But it was not Dr. Wax's fault. Despite that, the plaintiff is suing Dr. Wax for negligence. In doing so, they've taken on a burden of proof. Today, the plaintiff and the plaintiff alone has to prove to you that one, Dr. Wax owed a duty of care to her patient, that she breached that duty of care by acting unreasonably, and that those actions were the direct and proximate cause of that baby's paralyzation. They have to prove all that to you by a preponderance of the evidence. Members of the jury, they'll fail to meet their burden today, because it just wasn't fair. But it wasn't her fault. Now, even though we don't have a burden today, we're going to show you that this tragedy was not Dr. Wax's fault. We want you to pay attention to two simple facts throughout the course of today's trial. Dr. Wax made reasonable decisions, and the patient's condition contributed to her child's injury. So first, Dr. Wax made reasonable decisions. Today, you'll learn that childbirth is not new to Dr. Wax, that she did everything that she could to ensure that that baby was carried out safely. And when the baby got stuck, she tried multiple different methods to free that baby. She tried again and again and again until that baby was out. And we expect the plaintiff's expert is going to get up there and agree and testify that Dr. Wax made reasonable decisions throughout the procedures of this childbirth. You'll learn Dr. Wax didn't pull too hard. She didn't pull at all. And the plaintiff is not going to bring you an ounce of physical or conclusive evidence to show that she did. Now, you might be asking yourselves, Dr. Wax made all these reasonable decisions. Why did this child still end up in paralyzation? Unfortunately, childbirth is complicated. You'll learn that there is only so much a doctor can do to deliver a child safely. Dr. Wax will testify herself today that the mother and the baby in that birth had conditions that were out of her control. The mother was medically obese, and the child was larger than she typically sees. You'll hear that medically speaking, a larger mother and a larger child could be the real reason why that child's shoulder was paralyzed. The real reason why her shoulder got stuck in that pubic bone. By the time Dr. Wax leaves that stand, it will be clear that this tragedy was not her fault. Now, members of the jury, you're going to hear today that Dr. Wax, she did all she could to safely deliver Charlotte Lee, that baby. And you'll hear that Dr. Wax took reasonable steps to ensure that that baby and her mother got out of that operation room alive. And at the end of today's trial, I'm going to remind you what happened to that little girl. It wasn't fair. But it wasn't Dr. Wax's fault. Thank you.
Thank you, counsel. Plaintiff case in chief.
Yes, Your Honor. The plaintiff calls Dr. Nat Garson to the stand. May I proceed?
You may. Doctor, do you understand that you're pre-sworn?
Yes.
Great.
Good afternoon. Could you introduce yourself to the court?
Good afternoon. My name is Dr. Nat Garson.
How did you become a doctor? Or my apologies, what do you do for a living?
I am a medical doctor specializing in maternal fetal medicine.
Can you tell us how you became a doctor?
Of course. I graduated from Cornell Med, and I've been practicing as an OBGYN since. I've delivered over 500 babies over the past 20 years and published on childbirth and shoulder dystocia.
What was your role in this case?
I was asked to testify about the complications in Barbara Lee's delivery of her daughter, Charlotte.
What materials did you review to do that?
Well, in addition to treating Charlotte myself, I read and relied on all the exhibits and depositions in this case. I also reviewed relevant medical literature.
Were those materials sufficient?
They were.
What method did you use to conduct your investigation?
Well, I compared the facts of this case to the literature in order to reach conclusions about whether the techniques employed by Dr. Wax were in line with the standard of care.
Did you reliably apply that method to the facts and data of this case?
I did.
Sir, could you reach a conclusion?
Yes. The evidence suggests that Dr. Wax likely pulled too hard on the baby's head during childbirth, leading to permanent and complete paralyzation of the baby's right arm.
Objection, Your Honor, under Rule 702C. May I be heard?
You may.
Yes, Your Honor. Right now, there is a lack of foundation as to this witness's methods and its reliability. All this witness said was that they reviewed some documents in this case and they compared that to the medical literature. We haven't heard any foundation of whether or not that method is reliable, and without it, it's improper under Rule 702C.
Counsel response?
Yes, Your Honor. This witness testified that he compared Dr. Wax's actions to the standard of care. Your Honor, that's the most reliable method you could have. He's comparing it to the standard.
May I respond?
You may.
Your Honor, opposing counsel can say it's the most reliable method that you can have, but we haven't heard that foundation. We haven't heard what this witness is determined to, what they relied on and how they determined that this was reliable, and without it, it's improper.
I tend to agree. I didn't hear the foundation for 702C. Can you lay that foundation for me?
Yes, Your Honor. Sir, is that a reliable method?
Yes, it's the standard used in this field, and it's what medical consultants are hired to do.
So can you finish telling us about that conclusion you reached?
Yeah, absolutely. The evidence suggests that Dr. Wax likely pulled too hard on the baby's head during childbirth, leading to permanent and complete paralyzation of the baby's right arm.
Okay, let's take a step back. What complications were there during Charlotte's delivery?
So Charlotte and her mother experienced a rare medical condition called shoulder dystocia.
For those of us who don't know, what is shoulder dystocia?
So shoulder dystocia is when the baby gets stuck in the birth canal. And I actually brought a diagram to better explain what that looks like.
We're now screen sharing Exhibit 3, which is pre-admitted pursuant to Stipulation 2.
No objection.
That's fine.
Sir, what are we looking at here?
So this is the most common form of shoulder dystocia. So as you can see, the baby's shoulder is stuck behind the mother's pelvic bone, and that's why it can't move further out of the birth canal.
Well, sir, what should a doctor do when they encounter a situation like this?
Well, there's a number of steps that doctors can take, but what they should be doing is gently guiding the baby's head out. Pulling too hard can damage the nerves in the shoulder and neck.
Gently pulling the baby's head out. Is that what the defendant did in this case?
No. When Charlotte got trapped against her mother's pelvic bone, Dr. Wax grabbed the baby's head and pulled hard.
Objection, Your Honor, to a lack of foundation under Rule 602. May I be heard?
You may.
Yes, Your Honor. The question as phrased was whether or not Dr. Wax pulled on that baby's head too hard. The witness just made a complete assertion that Dr. Wax did pull that baby hard, and they didn't lay any foundation as to what led them to that conclusion. Without it, it's improper under Rule 602.
Response, Your Honor?
Okay.
My very next question for this witness is, how do we know that? If I can proffer?
You may.
You're going to hear that this witness relied on multiple different statements from people within that delivery room that testified to this exact fact. Your Honor, it's not possible for me to ask this witness how he knows that until we know that he does in fact know it.
I tend to agree. If that's your next question, you can ask your next question.
Yes, Your Honor.
So, sir, how do we know that Dr. Wax grabbed and pulled the baby's head?
Well, there were other people in the delivery room at the time. So I brought a chart to better explain those findings.
We're now screen sharing the doctor's diagram.
Counsel, have you seen it, defense?
Yes, Your Honor, we have seen it before trial. We have no objections to them showing it to you right now, though we may object to how it's used.
That's fine.
So, sir, how many people were present during this delivery?
There were 4 individuals total. So Dr. Wax, her nurse, and the baby's parents, Mr. and Mrs. Lee.
How many of those people reported the defendant pulling on the baby's head?
3. Nurse Rosenfeld reports Dr. Wax pulling gently. Miss Lee reports feeling Dr. Wax pull hard. And Mr. Lee reports seeing Dr. Wax lean back and yank.
Objection, Your Honor, to hearsay within hearsay. May I be heard?
You may.
Your Honor, I'm objecting specifically to the witness's assertion that Mrs. Lee, the mother in this case, said that the doctor, Dr. Wax, pulled too hard. That's an out-of-court statement being offered to prove the truth of the matter asserted, and we believe that this statement is actually within another deposition made by a statement by a witness that was actually asserting what she said. It wasn't her own statement on another deposition, Your Honor. So it wouldn't meet the requirements of an unavailable witness testimony under Rule 804.
What? Oh, go ahead. You can respond.
So, Your Honor, I'm going to take these 2 pieces of hearsay one at a time. First, to the document this piece of hearsay is contained within. Your Honor, that's an exception under Rule 804. We've stipulated that that witness, Mr. Lee, is unavailable pursuant to Rule 804A. And Your Honor, it's an exception under Rule 804B because it's former testimony from a deposition. Now, Your Honor, in terms of the statement from Mrs. Lee, this is an exception under Rule 703. Experts can rely on otherwise inadmissible evidence as long as they relied on that evidence to form their conclusions, and the evidence is substantially more probative than it is prejudicial. In this case, the doctor's opinion is that the defendant pulled too hard on the baby's head. There is no evidence that is more probative in evaluating this opinion than a witness testifying that was in the room that the doctor pulled on her baby's head.
May I respond?
You may.
Yes, Your Honor. Rule 703 is not an exception to hearsay. That only goes towards disclosing certain underlying facts that led them to a particular opinion or conclusion. This is still an out-of-court statement, hearsay within hearsay from that deposition offered by Mrs. Lee, and for opposing counsel to put up Miss Lee reported pulling as evidence to this jury that Dr. Wax pulled too hard on that baby, they need to offer some other sort of exception to hearsay in order to offer this on this demonstrative, Your Honor. It's inadmissible hearsay within hearsay, Your Honor. It's improper.
Response, Your Honor?
Okay, before you respond, I tend to agree with you that the within hearsay part is resolved with the exception to 804. Let's just talk about the actual hearsay, a statement by Mrs. Lee. You said it's an exception to hearsay. I tend to agree with counsel. 703 is not an exception to hearsay. So explain to me why it comes in under 703.
Yes, Your Honor. Under Rule 703, that rule specifically states that we can disclose these facts to the jury as long as they are substantially more probative than they are prejudicial. Your Honor, the woman who was giving birth is saying that the doctor pulled on the baby's head. That's the most probative evidence that we can evaluate in this trial. There is no prejudicial value.
I agree. I'm going to overrule your objection.
Yes, Your Honor.
So, sir, can you finish telling us about who reported the defendant pulling on the baby?
That's right. It's the 3 people you see on the right here. Mr. Lee, Mrs. Lee, and Mr. Rosenfeld.
Well, sir, how many people say that the defendant didn't pull at all?
Only one person, Dr. Wax herself.
Then I want to talk about how that pulling affected Charlotte. How much force should a doctor use in this situation?
Well, Dr. Wax correctly noted that the most force a doctor should ever use is gentle traction. Any more than that could lead to the baby experiencing nerve damage.
Well, did Charlotte Lee suffer from nerve damage?
She did. She suffered permanent nerve damage in her shoulder, which paralyzed her right arm and hand entirely.
Doctor, how can we be sure that it was the defendant's pulling that caused Charlotte's paralysis?
Well, the fact of the matter is that it's highly unlikely that anything else could have caused this injury. In the entire literature, there's only a handful of studies that argue that injuries like Charlotte's can be caused by anything besides the doctor pulling too hard.
Objection, Your Honor. Under Rule 702B, may I be heard?
You may.
Your Honor, the witness just made an opinion as to the causal link in this case. That the patient in this case, Miss Lee, suffered from too much force, and that's what caused that child's injuries, only based on 3 studies or some studies that he mentioned a moment ago. That's not sufficient facts and data under Rule 702B to make an opinion about causation in this case.
Response, Your Honor?
Yeah, you may.
I believe opposing counsel is misunderstanding the witness's testimony. There weren't 3 studies that suggested that this was the causal link. This witness testified that out of the entire medical literature that exists, all of the studies that exist, all of them say that this type of damage could only come from that sort of pulling, other than 3. Your Honor, that's certainly sufficient foundation under Rule 702B.
Your Honor, may I be heard? Yes, Your Honor, we believe that based on this witness's prior sworn statements that they reviewed 3 other studies that had causes of shoulder dystocia by other forces such as internal maternal forces. That's why I was referring to that. I don't believe I was misstating the record. But still, there's not sufficient foundation about what that particular medical literature was in order for this witness to make an opinion in this case about what causal links were happening here. We need to hear more foundation about what that medical literature showed. What did he learn from that information? How did he apply that to the facts in this case? We haven't heard that into proper right now.
Counsel, correct me if I'm wrong. That was his opinion and conclusion at the very beginning. Isn't that the same conclusion he's making now?
Your Honor, I had a different understanding of his conclusion in the beginning. He just said that it was highly unlikely that any other cause or any other thing caused that child's injuries. I believe that was a little different from what he initially said.
Okay, counsel, one last response for you from plaintiff.
Yes, Your Honor, he testified to the foundation because he did testify to what those studies showed him. Those studies showed him that it's highly unlikely that there could be any other cause of that injury. He's not going to be able to tell you what every single one of those studies was. He's referring to the totality of the medical literature. There's certainly sufficient foundation by a preponderance of the evidence under Rule 702B for this opinion.
Yeah, I think this is a lot of stuff for cross-examination, which is fine. But for your direct right now, I'm going to overrule it as long as he's limiting it to that it's unlikely based on the studies and not just saying the causal, like there is no other cause that's possible.
Yes, Your Honor.
So, doctor, can you finish telling us about what those studies showed you?
So what those studies showed me is that it's highly unlikely that anything else could have caused an injury with the severity that we saw in Charlotte's case.
Well, now that we know about what happened, I want to talk about whether this was preventable. Was there any way for the defendant to know that a shoulder dystocia could happen?
Yes, there were several risk factors present in Barbara Lee's case, which made both shoulder dystocia and shoulder paralysis more likely.
Like what?
Well, Dr. Wax noted that the mother was medically obese and that the child was about 10 pounds, which is about 3 pounds heavier than the average. He acknowledges, I apologize, she acknowledges that both of these are risk factors for shoulder dystocia.
Well, do you know if the defendant informed the baby's parents about these risks?
To the best of my knowledge, the parents were never informed of any risk factors. Mr. Lee even stated that Dr. Wax told him and Miss Lee there were no particular risks to this pregnancy.
Nothing further.
Thank you. Cross?
Yes, Your Honor. May I proceed?
You may.
Now, Doctor, I want to clear up some things you mentioned a moment ago about those studies you talked about on direct examination, because you said you did a comparative analysis of the studies to this case. Isn't that true?
That's right. I reviewed the relevant medical literature.
Exactly, sir. But you didn't bring any study with you to court today, did you?
No, I didn't, though I'm happy to disclose any of the studies that I relied upon in my analysis.
I'm not asking you to disclose anything. I'm asking about what you brought to court today, and you did not bring any study to court today about those studies, did you?
No, today in court, I'm presenting on my findings based on those studies that I reviewed.
Well, sir, today is actually the first day that you've ever testified using this method. Isn't that true?
That's right. I'm an OBGYN. I practice in the clinic, and this is, the first time I've testified in court.
That's a yes. The first day you've ever testified about that method.
Yes, though it's a method which is relied upon by other doctors who are asked to review cases like this.
All right, doctor, you talked a lot about on direct examination what Dr. Wax should have done, but let's talk about what you've never done in your practice. You've never delivered a baby with shoulder dystocia, have you?
Not with this specific type of shoulder dystocia.
Well, you haven't delivered a baby with shoulder dystocia, period.
Well, so shoulder dystocia is an umbrella term. It just means that the baby is awkwardly positioned in the womb. It's not a strict binary of yes or no. So I have dealt with mild cases of shoulder dystocia, but not one that's really comparable to this case.
Is it your testimony here today that you have delivered a baby with shoulder dystocia before?
No, it's not. Just to be clear, I've reviewed cases which are similar, but I've never done a case which is exactly like this.
Exactly, sir. You've actually never been faced with having to deliver a baby within 5 minutes, have you?
I mean, all babies, all deliveries take a very short amount of time. I mean, there are certainly babies which have been delivered by me in less than 5 minutes. I'm not sure exactly what you mean.
Well, sir, I'm going to direct you back to my question. You never had a time limit of 5 minutes to deliver a baby. That's either yes or no.
I mean, certainly, in cases I've dealt with, there have been time limits.
Well, whenever a baby has shoulder dystocia, you got to deliver the baby within 5 minutes, right?
That's true, but it's absolutely not the only case in which you have to deliver a baby quickly. In all sorts of complications, there are time limits because, it's a very delicate procedure.
Doctor, I'm not asking about any other cases. I'm only asking about this case. In a case of shoulder dystocia, you have to deliver that baby within 5 minutes.
That's right, yes.
Dr. Wax delivered that baby within 5 minutes, didn't she?
That's right. He did deliver the baby, though there were complications with the birth. As I mentioned, the nerves connecting the spinal cord to the shoulder were completely severed.
But that's a yes to my question. It took 5 minutes.
I believe it took about 1 minute, yes.
Now, sir, you were not in the operating room with Charlotte Lee when she was born, were you?
No, I was not.
You've never been in the operating room with Dr. Wax, period, have you?
No, I have not.
You've never even seen Dr. Wax practice medicine at all, have you?
No, I only reviewed the work that he did in this case.
Well, let's talk about whether or not the patient's condition could have contributed to this injury. Now, you'd agree that the patient, Barbara Lee, was a larger mother, wouldn't you?
That's right. She had an excess weight.
You'd agree that the baby, Charlotte Lee, was a larger baby, isn't that true?
That's right. And these risk factors were apparent well in advance of the delivery.
But that's a yes, Charlotte Lee was a larger baby.
That's correct.
Larger mothers are more likely to experience shoulder dystocia, aren't they?
That's correct.
Larger babies are more likely to experience shoulder dystocia.
Yes.
Now, sir, the father of that child claimed that Dr. Wax yanked that baby. That's what they claim?
That's correct. He said Dr. Wax leaned back and yanked.
But he also said he never saw the hands of Dr. Wax on that delivery table, didn't they?
That's correct.
Now, you can't rule out that maternal forces caused that baby's injury, can you?
Right. Well, there's a very small subset of the scientific community which believes in what they call internal maternal forces. It's a tiny fraction of the scientific literature that's available. But that's a yes to your question that we're unable to rule it out conclusively.
Well, I just want to clear some things up for the jury because I'm not asking about any subsets of the medical community, so I'm asking about your opinion. And you can't rule out that maternal forces caused that baby's injury. That's either yes or no.
That's right. I believe it's highly unlikely, but we're unable to rule it out.
That's a yes, sir?
Yes, it's highly unlikely, but yes.
Sir, let's talk about the decisions that Dr. Wax made based on that patient's condition. Now, you'd recognize Dr. Wax's delivery note if you were to see it today, wouldn't you?
I would.
Your Honor, we're about to screen share what's been pre-marked for identification as Exhibit 1.
Okay,
No.
this is not an evidence, correct?
Not in evidence yet, or we're about to lay foundation to move it into evidence.
Okay, is that fine with you, plaintiff's counsel?
Yes, Your Honor, as long as they lay the foundation.
Now, Dr. Garrison, this is that delivery note, isn't it?
Yes,
Looks to be fair and accurate.
it does.
And you know it's standard practice for doctors to make a delivery note on the date of birth or soon thereafter, right?
Yes.
Our defense moves Exhibit 1 into evidence.
Objection, Your Honor, to hearsay.
Response?
Yes, Your Honor. This would meet an exception to hearsay Rule 803.4, a statement made for medical treatment in furtherance of it. So first of all, we had to show that this document talks about a patient's medical history under prong 803.4a. This document talks about patient Lee was admitted for the induction of the view of elevated blood pressure. That describes her medical history. And also on prong B, we had to show what procedure or what practice was happening here. This was about the birth of their child, Charlotte Lee. Therefore, it would meet the exception under Rule 803.4.
Response?
Yes, Your Honor. Rule 803.4 is supposed to be used for patients making statements to their doctor in order to get medical diagnosis or treatment. Your Honor, this certainly doesn't fall under that exception.
Yeah,
May I
that.
respond?
Go ahead.
Yes, Your Honor. Nowhere in 803.4 does it say that the declarant has to be a patient or the person hearing that statement has to be a doctor. It just says that it has to be a statement made in furtherance of a medical treatment or diagnosis. And this document does just that.
Response?
Go ahead.
It doesn't say that it's a statement about medical diagnosis or treatment, or even in furtherance of medical diagnosis or treatment. It says it's a statement for medical diagnosis or treatment. This isn't a statement made by a patient to get treated or diagnosed. It doesn't fall under that exception.
Yeah, my understanding of 803.4 is it's statements from patients to doctors to get treatment and not the other way around. So these don't look like statements from a patient to a doctor to me. Do you disagree, counsel?
Your Honor, I don't disagree with that. May we talk about these statements without moving this document into evidence pursuant to Rule 703 like opposing counsel did on direct examination, because it goes directly to their conclusions in this case.
Do you have a response to 703?
Yes, Your Honor, we do believe there's significant prejudicial value to this evidence. Your Honor, if you take a look at that last line, the defendant states that at no time was any traction applied. But Your Honor, we've already heard on the record that every single other person in that delivery room has stated the opposite, that the doctor did in fact pull on that baby's head.
May I respond?
May.
Yes, Your Honor. Opposing counsel's argument goes to weight, not admissibility. This document is incredibly probative to this case because this witness's opinion goes towards whether or not Dr. Wax's actions were reasonable on the day that they delivered that baby. And I anticipate through my line of questioning, I'm going to show that the actions that Dr. Wax took in this document and the statements that they relied on in coming to their conclusions, this witness's opinion is that their decisions were reasonable. And the fact that they say at no time was any traction was applied is a matter for weight, and the jury can give as much weight as they want to that statement.
I'm not gonna let this document in. If you want to ask certain statements about the document, we can go through those statements and opposing counsel can object as she needs to, but I'm not letting this document in.
Yes, Your Honor. All right. Now, Dr. Garrison, you'd agree with me that when dystocia happens, a doctor can reach into the birth canal to check the position of the baby's shoulder. Isn't that true?
Dr. Garson, and yes.
Now, you know, Dr. Wax stated that they had the patient stop pushing and check the position of the shoulders. Isn't that true?
That's right.
That's a reasonable decision, isn't it?
Yes, that's the proper procedure in this case.
You know, a doctor can try to change the position of the baby's shoulders in the canal. Isn't that true?
That's right, and I think that's also reasonable. To be clear, the only thing that Dr. Wax did that I object to on the day of the delivery was pulling on the baby's head.
Well, that wasn't my question, sir. I'm asking about what else happened. And you know, a doctor can reach into the canal to rotate the baby's shoulder.
That's correct. So typically, doctors try to release one arm, and then there's more room in the canal for the other arm to escape.
And that's a reasonable decision.
It is.
Now, sir, you also know that a doctor, when one arm is stuck, they can release the arm that's loose out from the mother.
That's right, yes.
Dr. Wax said that they delivered the left arm that wasn't stuck easily. Isn't that true?
That's right. That's the posterior arm delivery, yeah.
And that was a reasonable decision.
That's right.
Doctor, in total, you believe Dr. Wax chose reasonable procedures for her
Yes.
treatment?
So I'm sorry, I think I cut you off.
you believe Dr. Wax made reasonable decisions for her patient. Isn't that true?
Well, I believe that Dr. Wax chose reasonable procedures, but not that she implemented those correctly. So I believe that she pulled too hard on the patient's head after she chose the correct procedures.
I'm not asking about what you claim about that pulling, sir. I'm asking you about the procedures that happened, and you believe Dr. Wax chose reasonable procedures. Yes or no?
That's right.
Thank you. Nothing further, Your Honor.
Any redirect on that?
No redirect, Your Honor.
Okay. So this witness can be excused.
Thank you, Your Honor.
With that, the plaintiff rests.
Great. Defense?
Yes, Your Honor. The defense calls our first witness, Dr. Samantha Wax.
Dr. Wax, do you understand you're already sworn in?
Yes, thank you.
You may proceed.
Yes, Your Honor. Good afternoon, ma'am. Could you please introduce yourself to the members of the jury?
Hello, my name is Dr. Samantha Wax.
Now, Dr. Wax, we heard a lot today about what happened during the delivery of Charlotte Lee, so I just want to cut to the chase. Did you pull that baby out during that delivery?
No, absolutely not. I never pulled on Charlotte. I never yanked her out of her mother. All I did was gently guide her head during her birth.
Well, let's take a step back and talk about how you became a doctor. Where'd you go to school?
Well, I graduated from UCLA in 1985 and then UCLA Medical Center in 1990.
What kind of doctor are you?
I'm an OBGYN.
What does an OBGYN do?
So I specialize in pregnancy, childbirth, and female reproductive health care. And so at this point in my career, I've delivered thousands of babies for so many families. And, it took a lot of schooling to get here, but it's all worth it. It's a very rewarding job to have.
Objection, Your Honor, to improper character evidence may be heard.
May.
Your Honor, this witness just testified that she's delivered thousands of babies successfully. Your Honor, this is my apologies. This is inadmissible under Rule 404B. Opposing counsel is using a prior act of this witness successfully delivering these babies in order to show character traits of being careful and rule-abiding, that she followed standard procedures, to show that she acted in accordance with that trait in this case, that she followed that standard procedure and didn't pull on the baby's head.
Response?
Yes, Your Honor. Under Rule 404, we have to be offering a prior action for action in conformity therewith and be offering a specific character trait for that purpose. We're not offering this under Rule 404 as improper character evidence, no. We're offering this to show this witness's knowledge under Rule 404B2. That this witness has knowledge of how to give reasonable childbirths, and therefore she's able to testify to what she thought was a reasonable practice in her practice, Your Honor. It's admissible.
Response, Your Honor?
Go for it.
In order for that 404B2 knowledge exception to apply, opposing counsel needs to lay that foundation that these births are at least somewhat similar to the birth that we're considering in this case. The fact that she knows how to deliver a baby under conventional circumstances doesn't mean that she would know what procedures to follow in this specific complication.
Response?
Okay. Last one. Go for it.
Yes, Your Honor, we did lay that foundation. The simple fact that she has given multiple births, not just 100, not 200, 1,000 births in her career goes to show this witness has thorough knowledge of what's reasonable in terms of medical practices. We're going to show later on in this direct examination what she believes was reasonable in a case of shoulder dystocia, and we're going to get to the point that opposing counsel was talking about.
Okay, so why don't we get to that point first, and then you can elicit this testimony after you get there.
Yes, Your Honor.
Or we can, actually, I'll change it this way. We'll bring it under 104B, and then you can re-bring it in when it's actually the foundation has been laid for now. And then opposing counsel, you can object if you need to object at the time.
Yes, Your Honor. Now, ma'am, have you ever confronted a case of shoulder dystocia before?
I have a total of 5 times, excluding the case of Charlotte Lee, and each one of them was a successful delivery.
Now, Dr. Wax, let's talk about the condition of the patient that you had, Barbara Lee. How did you meet the plaintiffs in this case?
So they became my patients in April of 2018 when Barbara first became pregnant, and I was her obstetrician throughout the entire duration of her pregnancy.
Based on your experience in having cases like this, did you find any risks associated with Miss Lee's pregnancy?
Yes, there were two things that I considered risk factors.
Let's talk about each of those. What was the first risk factor you found?
So before the birth, we found that the baby, Charlotte, was 10 pounds, and that's about 3 pounds heavier than the average newborn.
Well, how might a larger newborn cause a dangerous childbirth?
So in my experience, larger babies are more likely to get stuck in the birth canal because of their larger size.
Now, you mentioned you found another risk for this childbirth. What was that second one?
So the mother, Barbara, was 5'1" and 170 pounds, which classifies her as medically obese. And, in my experience, mothers at that size tend to be stronger pushers.
Well, how might a stronger pusher cause a dangerous childbirth?
So if the baby somehow gets stuck in the birth canal, it can be dangerous for the baby if the mother is a strong pusher. Because if the mother is pushing while that baby is stuck, it can cause serious injury, potentially nerve damage, leading to paralysis.
All right, Dr. Wax, let's walk the jury through how you delivered this baby, Charlotte Lee. When did you arrive to the operating room?
I arrived a little after midnight, at around 12:10 a.m. on January 2nd.
What was the plan?
Well, the plan was to safely deliver Charlotte Lee.
Did everything go according to plan?
It unfortunately did not.
Dr. Wax, what happened?
Well, the mother was pushing, and I was gently guiding the baby's head when the baby stopped moving.
Why they stopped moving?
Well, I felt around the baby's neck and shoulder, and I realized that the shoulder was stuck on the mother's pubic bone, which is something we call shoulder dystocia.
Well, what'd you do when that baby got stuck?
I immediately told the mother to stop pushing, and I told my nurse to set a timer for 5 minutes.
No, ma'am, why'd you tell your nurse to start that timer for 5 minutes?
Because if the baby was not out of the birth canal within 5 minutes, there could be serious risk due to lack of oxygen because of the position the baby was in. It could lead to, serious damage if a baby is deprived of oxygen for too long. So it was an emergency situation, and we had very limited time.
What happened after that nurse set that timer?
Well, the mother was already in a birthing position that was supposed to help free that baby's shoulder, and it wasn't working. And so I tried to reach in to rotate that baby, but that was also just not working.
No, ma'am, what happened after you tried to get the baby out?
Well, I was able to deliver that top arm, the arm that was not stuck, to create more room in that birth canal for that right shoulder to become unstuck. And that's exactly what happened. And that right shoulder and right arm spontaneously delivered on its own.
Dr. Wax, was this a successful delivery for you?
Unfortunately not, because when that baby was fully delivered, I noticed her right arm wasn't moving and she was paralyzed. But given the risk factors and the fact that this was an emergency situation, it's a success in the sense that both the child and the mother survived.
Thank you. Nothing further, Your Honor.
Thank you. Cross?
Your Honor, before we proceed with Cross, could I re-raise my objection to improper character evidence, to that evidence that was conditionally admitted?
Sure.
Your Honor, the witness testified that there have been thousands of births or babies that she's delivered successfully. Now, the foundation that Mr. Wesley laid was that there were 5 births in particular that were similar. But Your Honor, only those 5 births are admissible under Rule 404b2 with that knowledge exception. The other thousands of births, well, they don't show knowledge because they're not sufficiently similar.
May I respond, Your Honor? Your Honor, every single birth that Dr. Wax has confronted does not have to be exactly similar and exactly shoulder dystocia in order for her to help her understand what is and what is not reasonable in terms of medical practices. She spent the entirety of her direct examination talking about what she did and why she did it, and those prior experiences, every single last one of them, informed her knowledge on how to take care of this patient. We're only offering it to show the knowledge, and we did that. We've provided enough foundation to show that that was what helped her in the care of this patient, Your Honor, under Rule 404b2.
It's your objection, so I'm gonna give you a last crack. Go for it.
Yes, Your Honor. Pursuant to the exception that Mr. Wesley has cited, they do have to prove that the births are sufficiently similar. Because, Your Honor, in different circumstances, there's different procedures that need to be followed. So in births without any complications, well, that wouldn't provide knowledge of the procedure to follow in a birth with a complication.
I'm gonna overrule your objection, but with the limiting instruction that it's only gonna go to knowledge and not for action and conformity therewith. And
Yes, Your Honor.
that we can move towards cross.
May I proceed?
You may, sorry.
Good afternoon, Dr. Wax.
Good afternoon.
Ma'am, you knew before you ever stepped in that delivery room that if you did your job wrong, well, a little girl could be paralyzed, right?
Well, yes, of course. That's why I have 34 years of training behind me.
Ma'am, you knew that months before you ever got in that delivery room. Isn't that right?
Absolutely.
Let's talk about how you knew that. Because like you told us on direct examination, you examined Miss Lee before that delivery happened, right?
I did. I was her obstetrician for a total of 9 months.
That's right, ma'am. 9 months earlier, you found out that she was medically obese, correct?
That's right.
Ma'am, you can agree that that's a risk factor for shoulder dystocia, right?
That's right, in combination with the fact that her baby was 10 pounds, which is 3 pounds larger than the average size newborn.
Well, ma'am, we're going to get to that in a second, but for now, you can agree that a medically overweight mother, well, that could be a risk factor for shoulder dystocia, right?
Right.
Can also be a risk factor for the baby to get paralyzed.
It can be, yes, if the baby is larger, especially.
Ma'am, like you just told us, well, Charlotte was a big baby, right?
That is true.
She was 3 pounds over the average weight of a baby.
Exactly.
Ma'am, you knew that she was a larger than average baby before she was delivered, didn't you?
Of course, yes.
Ma'am, you can agree that that's another risk factor for shoulder dystocia.
It is, yes, in combination with the fact that the mother was also a larger patient.
That's right, and it's also a risk factor for the baby to get paralyzed, right?
That's true.
So now, ma'am, if you found 2 different risk factors that could cause birth complications, well, you must have gone straight to Mr. and Miss Lee and told them that, right?
Of course, yes.
Ma'am, are you telling us today that you can be certain that you told Mr. and Miss Lee about those birth complications?
Yes, I'm sure I told them.
Well, ma'am, isn't it true that you actually can't recall if you told them?
I couldn't tell you the exact date that I told them. I had a total of 15 appointments over the span of 9 months with them, but I'm sure that I told them.
So, ma'am, let me get this straight. You can't tell us what appointment it was, right?
No, I couldn't tell you exactly what appointment or what date I told them, but again, I'm sure I told them.
That's right, ma'am. You can't tell us what week it was, right?
No, because again, this was 15 appointments over the span of 9 months. I saw them pretty frequently.
So, ma'am, you can't tell us what week that was?
Not the exact week.
You can't tell us what month that was?
Again, no.
Ma'am, you've actually been sitting in court all trial, haven't you?
I have, yes.
So you heard Dr. Garson testify earlier?
I did. I was present for his testimony.
Well, ma'am, you heard Dr. Garson say that the father of that child said that you never told them about those risk factors, right?
I did hear him say that, but again, I'm sure that I told the Lees of of these risks.
Ma'am, I understand that you're saying you're sure you told them, but the father of that child said that you told him there are no particular risks to this pregnancy. Did I get that right?
Right, that is what Mr. Lee said.
Then, ma'am, I want to talk, or my apologies, you actually have a medical file for Miss Lee, don't you?
I do, of course.
A medical file is 15 pages long, right?
Yes.
Ma'am, in those 15 pages, you didn't bother to mention a single one of those risk factors. Isn't that right?
No, there were no risk factors included in that medical file, just other general information.
But ma'am, I want to talk about what you did with that information. Because you didn't perform a C-section, did you?
No, of course not.
Ma'am, you say, of course not, when you learned that doing a traditional birth could lead to birth complications. Well, you didn't tell Miss Lee that she should pursue alternative birthing options, right?
Well, no, because creating a birth plan is collaborative between the doctor and the mother. It's not completely up to me whether Miss Lee should have a C-section or not.
Well, ma'am, I understand that, but I'm asking about that collaboration that you did. You didn't tell Miss Lee that she should consider doing a C-section, did you?
No, I did not believe that was necessary at all.
That's right, you went forward with a traditional birth, right?
Exactly.
You delivered the baby, right?
I did.
And her shoulder got stuck, just like those risk factors suggested, right?
It did. The baby, Charlotte, was experiencing shoulder dystocia during that delivery.
And when Charlotte got stuck, well, you put your hands on her head, didn't you?
No, I actually reached in to try to rotate her to get that shoulder unstuck, but unfortunately that was unsuccessful.
So, ma'am, after you did that, you put your hands on her head, right?
No, I actually was able to free her left arm, and that's when the right arm delivered spontaneously.
Well, ma'am, you told us on direct examination that you put your hands on her head to guide her out. Isn't that right?
Yes, after the arms were delivered.
So we can agree that you put your hands on her head, right?
Yes, because you have to support a newborn's head.
Ma'am, you pulled that baby out, didn't you?
I only gently guided the head out while she was coming out of her mother, while the mother was pushing.
So you're telling the members of the jury that you never pulled that baby's head? Is that right?
No, of course not. I would never do that.
Well, ma'am, let's break this down for a second. There were 4 people in that examination room, right?
That's right.
That was Mr. Lee?
Yes, and Mrs. Lee, the nurse, and myself.
That's right. Miss Lee,
Yes,
the nurse,
that's right.
and you.
Correct.
Ma'am, when Dr. Garson testified, you heard that Mr. Lee said that you pulled that baby out, right?
That is what he said, but I mean, he has to be mistaken. The only point in that birth where I applied any pressure on the baby was when I reached into the birth canal to try to rotate that shoulder. And then I was putting pressure on the shoulder, and I did not pull. So he has to be mistaken.
Well, ma'am, we'll get to whether he's mistaken in a moment. Right now, I'm just asking about the testimony that we've heard in court. You heard Dr. Garson say that Mr. Lee says that you pulled on that baby, right?
That is what Mr. Lee said.
You heard Dr. Garson say that Miss Lee says that you pulled on that baby.
That is what Miss Lee said, but again, she was probably just feeling that pressure from me trying to rotate the baby.
Ma'am, you heard Dr. Garson say that your own nurse said that you pulled on that baby. Yes or no?
My nurse said that I used gentle traction, but even then, I only gently guided the head out once those arms were delivered. I never pulled on that child.
Ma'am, I'm asking about the testimony we've heard in court today. Dr. Garson told us that your own nurse said that you pulled on the baby's head. You heard that, didn't you?
She said I used gentle traction, not necessarily that I pulled.
I'm asking about what Dr. Garson said in court, not what you think her testimony is. Dr. Garson said that that you pulled on the baby's head. Yes or no, ma'am?
That's what Dr. Garson said.
So, ma'am, you're telling us that all three of those other people in the examination room, all of them, were mistaken?
Yes, that's exactly what I'm saying. I did not pull on Charlotte's head.
Ma'am, let me get this straight. The only person who's saying that you didn't pull on that baby's head, well, that's you, right?
Well, that's exactly right. I was the only doctor in that room, and it was an emergency situation, and I took the steps that I needed to be able to save that child's life.
So, ma'am, that's a yes to my question. The only person out of the 4 people in that examination room that's saying you didn't pull on that baby's head is you. Yes or no?
Of course. No, I'm the only doctor.
Nothing further.
Any redirect?
No redirect, Your Honor. May she step down.
You may.
And with that, we rest our case in chief. We have no further witnesses.
Great. Are you guys ready for closings? Do you guys need a time check? Anything?
Defense is ready.
Your Honor, could we request a 60-second break before closings?
As long as that's allowed, then yes.
I believe that it is.
Then yes, you can have your 6-second break. All right, looks like we're ready.
Yes,
All
Your
right.
Honor.
Plaintiff, closing.
When the defendant pulled too hard, Charlotte Lee paid the price. Members of the jury, when you go to the doctor, you expect them to take care of you. You expect them to use their best medical judgment, to make informed decisions. You expect them to give you the information you need to make decisions about your own health. What you don't expect is for your doctor to abandon standard procedure, abandon their years of medical training and hide crucial information from you. When Barbara Lee went to that delivery room, she didn't expect the defendant to paralyze her baby for life. But that's exactly what she did. That timer ticking, the defendant didn't know what to do. She knew she had to get that baby out, and so she panicked. She pulled. She grabbed and she pulled as hard as she could. But when the defendant pulled too hard, Charlotte Lee paid the price. That's why we're bringing a claim of negligence against the defendant. Now, in bringing that claim, we take on a burden of proof. We have to show by a preponderance of the evidence, meaning more likely than not, that the defendant acted unreasonably in their care of Barbara and Charlotte Lee, and that in doing so, they harmed Charlotte. They caused her paralysis. We met that burden, and we did it by focusing on 3 facts. First, the defendant ignored the risks. Second, the defendant pulled too hard. And third, Charlotte Lee paid the price. Let's start with that first fact. The defendant ignored the risks. Because you heard that it wasn't some shocking turn of events that Charlotte Lee got stuck or that Charlotte Lee got paralyzed during that birth. No, the defendant told you on the stand today that she knew months before that delivery ever happened that Barbara Lee was prone to complications, the same complications that paralyzed Charlotte. But what did she do with that information? Well, she certainly didn't tell the Lees, despite what she told you in court today. No, you heard that Mr. Lee? Well, he told us that the defendant actually told him there were no particular risks in that pregnancy, that everything was perfectly fine. What else did the defendant not do? Well, she didn't record those risks in her medical file. I mean, Mr. Wesley's been talking about those risks all day as if that's a reason, some sort of unforeseeable reason that that Charlotte would die. But members of the jury, the defendant didn't even bother to record them in that medical file. 15 pages and not a single word. That's how important those risk factors were to the defendant. And members of the jury, well, if pushing a baby that big is such a big problem, why didn't she have her get a C-section? Why not avoid that traditional birth in the first place? Why not tell her about the other options? You see, the defendant's actions don't make sense. Imagine that there's a person standing on railroad tracks and there's a train coming straight at them. You should probably tell that person to get off the tracks, especially if you're responsible for their health, especially if you're their doctor. But members of the jury, that's Dr. Wax's medical philosophy. No, Dr. Wax's medical philosophy is that you should wait until the train hits them. It's not a preference, members of the jury, that's negligence. The defendant ignored the risks. Brings us to that second fact. The defendant pulled too hard. Because members of the jury, you heard today that the defendant, well, she didn't just pull on that baby's head. No, she leaned back and yanked. That's what the father of the baby said when he testified before this trial. Now, the defendant can get up here and tell you that she didn't pull on the baby's head, but members of the jury, this isn't a he said, she said. There were 4 people in that examination room, and 3 of them, including the defendant's own nurse, all said that the defendant pulled on that baby's head. The only person who's telling you anything different is the defendant herself. So what is the defendant asking you to believe today? That all 3 of those people in that examination room suffered from some collective psychosis where they all misremembered the exact same sequence of events? That doesn't make sense. And neither does the defense's theory today. I mean, they told you that Charlotte Lee was injured from internal maternal forces. Members of the jury, when Dr. Garson took the stand, the only person who looked at all of that medical literature, well, he told you that's basically a pseudoscience. That out of all those studies that exist, all of those scientists that are studying this, there's only 3 studies that suggest that that's even possible in the first place. Every single other piece of research, well, it says But the only thing that can cause the type of injuries that Charlotte had is the defendant's actions, pulling on the baby's head. The defendant pulled too hard. And that brings us to our third fact, because it was Charlotte Lee who paid the price. You see, when the defendant ignored standard procedure, when the defendant ignored her years of medical training, when the defendant ignored her reason, she got to walk out of that hospital perfectly healthy. It wasn't the defendant who suffered, it was Charlotte Lee. It was Charlotte Lee who left that hospital with only one arm working. Members of the jury, we can't change that today. We can't change what the defendant did. But what we can do is give justice to Charlotte and her family for what they went through, for what the defendant did to them. What we can do is hold the defendant accountable. She pulled too hard. And Charlotte Lee paid the price. Find the defendant liable. Thank you.
Thank you. Defense counsel, closings.
Yes, Your Honor. It wasn't fair, but it wasn't her fault. Members of the jury, I'm sure at some point in your life you've been frustrated at the circumstances you're in. If you get laid off from your job during a recession, you can't turn around and sue the government for raising your taxes. If you find out that you have a rare genetic disorder, you can't go back in time and sue your great-grandfather. If you're injured after a medical procedure, that doesn't mean you always have a lawsuit. The tough truth is that when you find yourself in these frustrating situations, the first person you want to blame isn't always the right person to blame. There are conditions, there are circumstances out of your control that just make situations unfair. And in this case, we agree what happened to Charlotte Lee, it was not fair. But it was not Dr. Wax's fault. Now that's just something the plaintiff couldn't come to terms with. Today, the plaintiff and the plaintiff alone, they had the burden of proof. They had to prove to you that Dr. Wax breached her duty of care owed to the plaintiff, and that in doing so, the defendant caused the harm to that baby Charlotte. They had to prove that to you all by a preponderance of the evidence. To do that, they needed to bring you evidence. Conclusive evidence that proved that harm would not have occurred without Dr. Wax's actions, and that harm was a reasonably foreseeable result of her actions. Members of the jury, what evidence did they bring you today? Not much. No studies, no literature, nothing. All you have is the words of one of their witnesses today. They fell far short of meeting their burden today. So now I'm going to walk you through how you know the plaintiff failed to meet their burden. And I'm going to do that by asking you to focus on the two key aspects of today's trial that we talked about in opening. Dr. Wax made reasonable decisions, and the patient's condition contributed to that injury. So let's talk about those reasonable decisions Dr. Wax made. Dr. Wax, she spoke to you today. And you learned today that she is a seasoned professional, decades of experience in her hand. She took that stand, swore an oath, told you the truth because she has nothing to hide. Every decision that she made was with the patient in mind. And so when that baby started coming out of that mother, Miss Lee, and that baby got stuck, she knew she had 5 minutes to save that baby's life. So what did Dr. Wax do? What did she do? She did what she thought was tried and true. She kept the mother in the position that would help free the baby, free that baby's free shoulder to deliver her safely. She tried other things, they didn't work. She tried to gently free the baby's arm at first, and it didn't work. And finally, she was able to get that arm out of that mother. You know she saved that baby's life. What happened, it just wasn't fair. Dr. Wax made reasonable decisions. And you don't just have to take her word, rely on her opinion that she made reasonable decisions. Their expert got up on that stand and told you that they agree that Dr. Wax made those reasonable decisions too. Dr. Garson got up on that stand, even though he didn't have any evidence with him. No studies that he talked a lot about that he compared to the facts and issue in this case. No. Dr. Garson told you that when they checked the position of the baby's shoulder, reasonable decision. When Dr. Wax tried to keep the baby's shoulder and get it out safely, that was a reasonable decision. When one arm was stuck and she tried to get the other arm out, that was a reasonable decision, members of the jury. Time and time again, Dr. Wax made the right and reasonable decisions. Ms. Volpert just got up here and told you that Dr. Wax failed to inform her patient about the risks of her pregnancy, that somehow this patient didn't know that a C-section was available to her, even though she's pregnant. Dr. Wax told you that she simply told her patient what was available to her, that she had 15 conversations about this woman's pregnancy. Sure, she may not remember the week, the date, the time 5 years ago, but it sure did happen. And now Ms. Volpert, she wants and needs you to believe that Dr. Wax, she pulled this baby, and that was what resulted in that paralyzation. And they brought you a chart today to try to prove that. Now, the baby's father told you that he saw Dr. Wax yank that baby, and Dr. Wax told you that, no, she didn't. So what you have to ask yourself is, who do you believe? The plaintiff, who the plaintiff's own expert admitted they never saw Dr. Wax's hands touch that baby? Or the person with the medical license who's delivered over 1,000 babies in her career? You know you should believe Dr. Wax when she says that she didn't yank that baby, because someone else said that they were using gentle touch, the nurse. And that's exactly what Dr. Wax did. Ms. Volpert can say that her case isn't based on a he said, she said, all that she wants, but all of her stories, all of the witnesses, their stories are different. They can't change that. At best, this case is based on a he said, she said, with absolutely zero conclusive evidence. I mean, we just got to take their word for it. We just got to take the plaintiff's word for it that this yank actually happened. No video footage, nothing. When her livelihood is on the line, they just want you to take their word for it. That's not how this works. You need evidence. And they didn't bring that to you here today. And that brings us to our second simple fact, that her patient's condition contributed to that paralyzation. Now, you learned today how the plaintiff was not Dr. Wax's typical patient. Dr. Wax didn't ignore those risks, no. Medically speaking, Miss Lee and her baby were larger than most patients that Dr. Wax has seen. Their expert agrees. Barbara Lee was a larger mother. Charlotte Lee was a larger baby. And I want to remind you of their burden today, because they had to prove to you that that pull was the direct and proximate cause of that baby's injury, that without that, that baby would not have been injured. Is it direct and proximate cause when their expert can't even rule out internal maternal forces in this case? No. They failed to prove causation. I mean, use your common sense for a second. Why? I mean, why would Dr. Wax risk her license, her practice, her money, her legacy, her livelihood to violently yank a baby out of a mother? Are you kidding me? That's not plausible. That's not probable. Members of the jury, that is not even possible. Why Dr. Wax would do such a terrible thing is a question they couldn't answer. Their case doesn't add up, and they did not meet their burden. Now, in a moment, Ms. Volpert will come before you and say that Dr. Wax, she should have done different things. Look, members of the jury, knowing what we know happened to that child, we wish this tragedy never happened. But what you heard throughout the course of today's trial is that Dr. Wax was not negligent. It just wasn't fair. And it wasn't her fault. Find Dr. Wax not liable. Thank you.
Thank you. Any rebuttal?
Yes, Your Honor.
You may proceed when ready.
Mr. Wesley just got up here and told you that this wasn't fair, but it wasn't the defendant's fault. Members of the jury, if this wasn't the defendant's fault, well, then why did she admit on the stand today that she knew that this pregnancy could go wrong and did nothing? If this wasn't the defendant's fault, then why does all of the research suggest that there's only one thing that could have caused injuries like Charlotte's, and it's the defendant's actions? If this wasn't the defendant's fault, then why does every single person in that examination room, other than the defendant herself, say that it was? That the defendant was pulling on that baby's head? The only fair thing to do is find the defendant at fault for what she did. The defendant pulled too hard, and Charlotte Lee paid the price. Find the defendant liable.
All right, I'll ask our judges to fill out their ballots. And then, given that Nick and Katie will literally never do this again, I'll ask you just to say your favorite thing from the round from each advocate. Keisha, I'm just missing yours, no rush. Oh, I have it. All right, so why don't we do Dylan, Claudia, Zach, Bill, Disha. You remember that order.
Hey guys, I first of all really liked it. I didn't even know AMTA did this sort of thing anymore, or the run up kind of thing. I thought it was more of a COVID activity, but I really enjoyed it. I think you both clearly were, I'm guessing, the top of the 16-person field or 8-person field or however big this field was, and I can tell you guys that were really prepared and probably deserved it more than the others. For Ms. Volpert, I really liked how prepared and polished you were on pretty much everything. What I really liked might not even sound like a compliment, but it is. You messed up on some pretty major things in your opening, mostly the burden, and you completely just fixed it, and it didn't rattle you, which I think is really good, because a lot of people are so memorized, they say something wrong and then they get screwed up. And you didn't get rattled by anything that happened at any point in the trial. And everything you did, for the most part, was really, really prepared. And I really respected that. Mr. Wesley, I thought your emotion was really good. Some might say it's over the top, but mock trial is not real life, and mock trial is over the top. So it makes you much more interesting to watch. It's very boring to see someone just be very monotone, same pacing for everything, same attitude for everything. And you varied, you had particular moments you clearly intended to focus on and clearly intended to have more emotion toward. And I could tell that you were really prepared to do that. And I think it came across well. Like I said, it might not always work for everybody, but I at least did mock trial insanely long enough to respect and appreciate the emotion and chaos that comes with doing this activity. But both of y'all did really, really well, and you definitely deserve to be here.
Okay, I think I was next in that lineup. Obviously, fantastic job to both of you. Katie, you really, in your cross-examination was the highlight for me of your performance. You came out swinging, and I was here for it. Like, it's when the stakes are, like, stakes should be high in cases like this, when people's lives have been forever altered. And I think that you came out with the appropriate tone. I love a little righteous indignation, like, go be angry. And like, obviously you weren't over the top with it. So I was a really big fan of your cross-examination and just the passion. It's clear how much you care about this fake case, which is exactly what you have to do to win mock trial. So slay. Nicholas, you were just so smooth. There are so many things about you that were so smooth. I think one of my favorite parts was actually like an objection that you lost. And it's like, one, you fought really hard. So even though like I wasn't on your side with the objection, judge wasn't on your side, but you fought really hard. But also when you lost, it was just like, okay, that's fine. And you still made all your points. You did exactly what you needed to do. It's like that confidence and poise and calmness that makes you a fantastic advocate. So great job to both of you, and good luck.
I think Bill's up.
Thank you very much. I thought it was a very good trial. It's a very short format to cover so much territory, but I thought there was something interesting about the demeanor of the two attorneys, and it's already been commented on. Ms. Volpert was angry and strong because of the wrong that was done to this poor child. And that came across very clear and was compelling. I think that Mr. Wesley was very empathetic and very careful and cool and calm simply because of the fact that, a jury is going to say, oh, we're going to pay a lot to the plaintiff and the doctor's insurance is going to pay for it. And Mr. Wesley was very compassionate about the fact that the girl had significant injury, but still was trying to make the case that the doctor did no wrong. There are a couple of key points where it would have been nice to know more. For example, during the cross-examination of the defendant, several times Ms. Volpert asserted that the nurse in the room said that the baby's head was yanked. And the doctor each time said, no, it was traction was gently used. It would have been nice to know exactly what that was. I was hoping Mr. Wesley was going to object to that cross-examination after the same question had been asked about 3 or 4 times and try and get it settled. What exactly did that witness statement say about the nurse? And because, of course, the plaintiff expert had relied on it. The other thing is, I think there should have been more attention focused on the fact that there were 2 lay people involved, even though one was the mother, and not skilled observers or medically qualified. And yet the doctor, the plaintiff doctor expert, relied on all of that. So there's some things that, even though both counsel did an extremely good job, I think could have been developed even further had there been more time involved, as in how was the expert relying on lay people, observers that weren't even close to the actual birthing process. So it was a very good trial, and I think a lot of good points were covered by an excellent job by both counsel. The this format, though, says there's still much more that could have been done. That just shows how rich this case was to provide material with which the attorneys could work, because they worked with a lot of it and there was still more. So the case was a good one for this type of process, to see how much could be handled in a short time. So thank you.
All right, I think I'm up. Great job to everyone. I think, I was asked sort of to name my favorite part, and it's going to be the same for both of you. And that's watching you deal with witnesses that were actually very skillful at sneaking answers in to their side, that helped their side. And both of you kind of confronting that on cross and figuring out how to circle back to your point and to emphasize your point. I think you both reacted and adapted to that. And, the witnesses deserve a hand too, because they did a great job of being pretty skillful in helping their sides out. And, if you move on, I would say one thing that you can take away from this that doesn't apply to this case, both of you were very mock trial-y, for lack of a better way of putting this. And you sound very mock trial-y. And I think the most compelling people at the absolute top of this tournament have a wide range of serious moments and conversational moments and genuine moments and mock trial moments, and bringing some depth to your attorneying will help you if you move on. But great job to both of you, and good luck.
You've heard me talk enough, and I know as the competitor, I don't want to hear myself talk either. So I'm just going to say you guys were both great. I would say the one comment I would give is just make sure you're listening to what the judge is saying. If I'm giving you hints of like you took it with the 104 when I said it was conditional and you raised the objection, I appreciated that. So like things like that, just like listen to what the judge is saying and be able to like incorporate that. And if I'm saying it's a good point for cross, like make sure you bring it up on cross. But other than that, I thought you guys were both fantastic, especially for a 24-hour turnaround. I know that's impossible. So good job for everything that you guys did.
Alrighty. The moment that everyone's been waiting for. Before I announce the winner, I'm going to stretch this out a little bit longer and make it agonizing for everybody. I want to recognize the two competitors, Katie Volpert from Penn, 11 attorney awards, a senior, and Nick Wesley, 7 attorney awards, a junior and an All-American. So these are two top-notch competitors, and this was a very, very good final round. And without any further ado, the winner of 2024 Trial by Combat Play-In Tournament. Katie, are you up for one more tournament? Because you're going to Los Angeles. Congratulations, Katie.
Oh my gosh, thank you so much.
And just a virtual or actual round of applause for Nick. That was a really fantastic final trial, and Nick won his morning round and deserved to be in this final. So congratulations to Katie. Thanks everyone for watching. And we've got one more Trial by Combat Play-In starting in 28 minutes. We'll see everyone there. Thanks to our judges.
Thank you so much. Thank you guys for judging. And Nicholas, you are absolutely fantastic.
So are you.